Hey guys, today we're going to talk about the doctrine of mistake in contract law. Under contract law, there is this concept that if parties, one or both of the parties are mistaken as to the terms of the contract may be void. So, if one or two parties enter into a contract under a mistake, the contract can either be completely void or voidable. Voidable contract means that it is valid until it is cancelled by the other party. It's called rescission. So whether a mistake has the effect of making a contract void or voidable depends on the manner in which the mistake arises. I will first talk about mutual mistake. If party A enters into a contract with party B, believing that he's purchasing, for example, 1,000 units of Sony DVD players. But this party is in fact intending to sell this party Sony television sets. Then there is no contract between the two parties because they have failed to reach any agreement on the subject matter of the contract. One thinks he's buying DVD players, the other party thinks he's buying television sets. So mistakes of this nature are commonly referred to as mutual mistakes. The transaction entered into under a mutual mistake relating to a fundamental, a very important aspect of the contract is void. It doesn't exist. The next kind of mistake that I'm going to talk about is called common mistake. Common mistake arises when there is an agreement between two parties on the basis of a mistaken assumption or belief shared by both of the parties. So an example is where A enters into a contract to sell B 1,000 television sets, but unknown to both of the parties, the goods, the television sets, had been destroyed by fire in a warehouse before the contract was entered into. So A enters into a contract with B to buy 1,000 television sets for $800 for a television set. But unknown to them, the television sets which are stored in a warehouse either in Singapore or in Japan are already destroyed. So in this situation, because of the destruction or non-existence of the subject matter, the contract may be regarded as invalid and void, even though it was properly formed. The more problematic situations arise when the common mistake relates to a less fundamental matter, a less important matter, such as the quality of the subject matter of the contract instead of the existence of the subject matter. So the law has to strike an appropriate balance between doing justice to the party who is disadvantaged by the mistake and protecting the other party's rights, his legitimate expectation that the contract bargain would be upheld and honored by the other party. So the common law and equity is a branch of the law which assists people when the strict interpretation of the law causes hardship. So the common law and equity has responded to this problem in several different ways. So while legal remedies, including under contract law, typically involve monetary damage, so they use money to compensate someone else for the breach, equitable relief, that means relief under equity, typically refers to things like injunctions, specific performance, restitution. A court will typically award equitable remedies when a legal remedy is insufficient or is adequate to help the innocent party. For example, courts will typically award equitable relief for a claim which involves a particular or unique piece of real estate, or such as where the plaintiff requests specific performance of a contract. So back to common mistake at common law. Common law means judge-made law, not laws passed by Parliament. So under the common law doctrine of mistake, importance is given to upholding bargains, to preserve the sanctity of contract. So at common law, a mistake as to the quality of the subject matter would generally not make a contract void unless the mistake in the contract has the effect of rendering the subject matter of the contract essentially and radically different from what the parties believed it to be. So the ambit of the common law doctrine of mistake is therefore extremely narrow, having little application outside of cases involving non-existent or destroyed subject matter. On the other hand, the doctrine of mistake in equity permits a more liberal approach, even if the mistake is not sufficiently fundamental to make the contract void at common law. Equity may still set aside the contract provided that the mistake is sufficiently serious. So, distinguishing between the different degrees of fundamental mistakes that are operative at common law and in equity is actually quite a difficult task. But nonetheless, the Singapore Court of Appeal in Chui Kin Keong and Digital Land Mall has appeared to favor the retention of this two-pronged approach. I will discuss this case in a separate video. So thanks for watching this introductory video on common and mutual mistake.